May I please, your lordship? My lord, I beg to mention item number 112 of regular part 2 list. I am praying, lordship, for take up the matter on Monday. Other sides are also there to inform lordship. Or matter we listed the part 1 list on Monday, lordship. 112. Urgency is there because one is already been retired regarding pension benefit, lordship.
Let us see.
May it please your lordship, I beg to mention item
Obliged.
number 18 of today's list docket. I am making this prayer on behalf of Mr. P.K. Roy, signature of the lordship. He is out of station, lordship. Matter may not be taken up today, lordship.
The fresh matter.
Conflict relating to conflict. I have taken consent of the other side, lordship.
Please something.
May it please, lordship. I beg to mention item number 12 of today's list. I have taken the consent of the other side. Therefore, we may be granted 4 weeks time to in order to enable us to file a reply to their affidavit.
Next. Next.
May I please, your lordship? I beg to mention item number 6 of daily list.
Yes. Yes.
Obliged.
What do you want?
Lordship, 2 weeks time.
May it please,
Obliged.
lordship. My lord, with the consent of the other side, I beg to mention item number 36, my lord. Let taken up this matter after 2 weeks, my lord.
Next.
Obliged.
May I please, your lordship, I beg to mention item number 20, lordship, with consent of the petitioner, lordship. Matter may be extended for the day next week any day.
20.
20, lordship.
20 is connected with 21 also.
Yes, lordship. We have consented, taken consent, lordship, of the petitioner.
You are for the respondent.
I am for the respondent, lordship, 14 to 27.
Why do you need time?
Lordship, some personal difficulty to do, we need to some
Next week.
extra.
Next week.
May please, your lordship. Lordship, I beg to mention item number 34, lordship. Matter may be passed over for the day, lordship.
Next.
My lord, I beg to mention item number 4 and 5. These matters may kindly adjourn for today as my senior is out of station. We have taken the consent from the other side. Kindly, my lord, brings the matter after 3 weeks.
Your lordship, I beg to mention item number 29. Matter may be come up after 2 weeks, your lordship.
Service. You will have to solve them again. The other side has left the premises mentioned in the address. Because by fresh notice. To respond, the council for the appellant shall furnish new address in a period of 1 returnable on 17th January. Next.
Obliged.
Lordship, a writ appeal, this may be allowed for listing on Monday, lordship. It has been filed on behalf of the state of Assam. There is an urgency in the matter, lordship.
Government there can't be any.
Lordship,
Next.
My lord, I beg to mention item number 46, my lord. I'm for the respondent, my lord. We have filed, my lord, affidavit day before yesterday, my lord, we have filed affidavit in opposition against the affidavit filed by the government. So let this matter come in the next week, my lord. Item 46.
You overtime. Next. Yes.
May I please, your lordship, with the consent of the other side, I beg to mention item number 50 of today's list. Your lordship, our senior Mr. S.N. Sharma was supposed to appear in this case, but unfortunately passed away. Your lordship may kindly adjourn the matter for 3 weeks, 4 weeks. 4 weeks.
I am appearing on behalf of the appellant, man.
Thank you.
With your lordship, man, anytime convenient, man, I travel down to do this matter. I'm being led by Mr. Nair in this matter.
No, we are conscious, but it's a
Very well, I was very shocked to hear such a news when I came down today. Anytime, man, made the 19th December, subject to lordship convenience.
some date will be given by us. Next. Next.
Okay.
Very.
Obliged.
May I please, I beg to
I'm
mention
obliged.
item number 11, man. Matter may be passed over for the day, man. Item number 11, admission, man. Part 1. Because my lord, Mr. Akapurkis though is not well today. Next week, my lord, anything.
Yes, sir. Yes.
Your Lordship, item number 3730. Lordship, may this matter come after 2 weeks.
Item number
37 and 38.
what about publication? Have you made the publication of the notice?
The Lordship will put in file affidavit.
Is the notice published in the newspaper?
Uh,
You are not aware.
I'm not aware, no.
2 weeks.
37, 38.
Yes.
Please, Your Lordship, with the consent of the other party, I beg to mention item number 2. Any matter may be adjourned for 1 week, Lordship.
Next.
Okay.
Hold on.
Item number 1 of daily list for motion.
Whether this PIL is against the National Highway and Infrastructure Development Corporation Limited, my lord, about the grievances of not providing service road and drainage system and underpass, my lord, at the most important place of Assam, the Koliabortini, my lord. And as per order dated 1/6/2022, an instruction was called for, my lord, from the NSIDCL, my lord.
Mr. Counsel, kindly turn to page 17 and 18 and look at your prayer.
My lord.
Kindly turn to page 18 and turn to your prayers, please. Now, whether it is 2-lane or 4-lane,
4-lane, my lord.
that is to be decided by High Court under 226.
No,
Or
my
it
lord,
is-
it is underpass and without providing the underpass,
That we understand by
But-
reading your prayers itself.
my lord.
This is not our job and jurisdiction to decide what type of highway it should be there. There should be a limit. Anything is brought in PIL. Go to the government. Nothing doing.
My lord, as per the government, they have also admitted, my
Mr.
lord.
Counsel, these are all policy matters.
My lord.
These are not subject matter of a writ petition under public interest litigation.
My lord,
Whether it
minute
should
is
be
there.
4-lane or 2-lane or tenal or detailed project report has to be submitted and all that. They are not our subordinate.
No, my lord, thing is that the public is suffering for which
Public
the
is
general
suffering,
meeting was
therefore-
held, my lord.
Did you approach the government? Did you approach the government?
Yeah, yes, my lord, this is the minutes, my lord.
Now go to page 33,
Page 26, my lord.
not 33.
Is the resolution
Yeah.
that was sent to the,
Therefore, how the highway is to be laid down and all that is not our go to page 37.
my lord, this is to be implemented as per the resolution, my lord.
Therefore, go to page 37. They are taking action, even page 38.
37 is a letter to the, yes, my lord, is a project manager, Simplex, my lord. It is from Deputy
Therefore,
General Manager.
At the most, we may direct the government to look into your grievance.
My lord, NSDCL also, they have also agreed.
That is what we are saying, that you will direct the authorities to take into consideration your petition. This is not our job. Which type of highway and 2-lane and 4-lane and tomorrow you will say it should be a cement
Only,
road
only
instead
the
of diamond
service
road.
route is to be provided because the Deputy Commissioner in page, my lord.
Mr. Counsel,
38.
these are all technicalities which we can go into in our jurisdiction under 220.
My lord, page 30 is a letter of additional deputy, they also given instructions to the highway authority that the water.
That is what you are not trying to listen to us. Therefore, we permit you to continue.
My lord.
The question is that we intend to direct the authorities to take decision in this matter. We can't go beyond that.
My lord.
This is not our jurisdiction. Which type of highway and Likho, heard Mr. Kukan. Yes, TCC Kukan for the petitioner and write the appearance. By way of this public interest litigation, the petitioner has prayed for the following relief. The records indicate that the efforts have been made by the government of Assam, which is evident from the minutes of the meeting held on 6/3/2019. The record also further shows indicate that the said demand has already been reiterated and the Ministry of Road and Transport and Highways, Government of India, is also made aware about it. As back as on 22nd of July 2021, the Deputy General Manager Project of National Highway and Infrastructure Development Corporation Limited has also drawn attention of the authorities for laning National Highway number 37A from kilometer 00 Kolibor Tinali Road Junction to kilometer 17.300 Rolabari Road Junction. The record further indicates that the government of Assam, through additional deputy commissioner in charge Caliber, has also reiterated the said stand of the government. The record indicates that because of non-action on part of the National Highway authorities, water logging has become a perennial problem in the area in question. We therefore deem it fit to direct respondent number 3 and 4 to look into the grievance raised by the petitioner as well as the correspondence on record within a period of 3 months from the date of the receipt of this order. The learned counsel for the petitioner shall also serve copy of this paper book upon respondent number 3 and 4. With this observation, the petition is disposed of. Next.
Matter number 3.
May I please, Your Lordship. What are your prayers here?
My lord, to raise the compensation, my lord, regarding compensation, my lord. Because their regulation, my lord, restricted only, my lord, the 4 lakhs, my lord, and earlier paid rupees 3 lakh each, my lord.
Now, this is a statutory provision of
This is ex gratia amount. No, not under the statute.
care is there or not?
There is not under the statute.
Care is there or somebody has removed it? There is a chair behind you or somebody has
Yes,
removed
yes,
it? Then please occupy this seat. Turn to your prayers. These regulations are formed under which provision?
My lord, this kindly see the regulation, lordship will find. My lord, page 49, my lord.
Mr. Pathak, now you stand up and go turn to page 49. Therefore, these are under section 53 of the Electricity Act.
Yes. This,
Now, these are statutory in nature.
these regulations were framed by using powers under section 52,
Hmm.
but the act itself does not contain any provisions for.
No, that
Yes.
may be so.
Yes, sir.
These are the regulations which you have formed
Yes, sir.
under your powers under section 53 of the Electricity Act.
Yes, sir.
Therefore, the quantum which is fixed. Now turn to prayer, both of you. Please turn to prayer. Of 4 lakhs is provided under the regulation.
Yes, sir.
Now he says that it should be 50 lakh.
Yes, sir.
It is not our lookout. These are statutory functions.
Lordship, I am relied on the honorable episcopal judgment, my lord.
Now, give us the judgment.
Yes, my lord, which was reported in 2014.
You give us the judgment. We are bound by it. By what type of regulation? We can understand you can challenge the constitutional validity, which is challenged very easily here.
My lord, arising out of Haryana, state in Haryana, my lord.
Let us look at it. Which paragraph, sir?
No, my lord, it's relevant to lordship, paragraph 7, lordship. This is a case of my lord, 4 years old.
That we will look into it. You just concentrate on the aspect which
Lordship.
we are telling you.
Para 9, my lord, lordship.
Paragraph number?
9, lordship, will the fact will be.
Okay. Which other paragraph?
My lordship, may turn now page paragraph 19, my lord. Honorable Supreme Court, after discussing all my lord relevant things, my lord, come to conclusion in para 19, my lord.
Please read.
In view of the law laid down by this court in the above referred cases, which are exclusively considered and granted just and reasonable compensation, in our considered view, the compensation awarded at rupees 60 lakh in the judgment of the land single judge in the High Court, out of which 30 lakhs were to be deposited jointly in the name of the appellant, represented by his parent as a natural guardian, and the chief engineer or his nominee representing the respondent Nigam in a nationalized bank in a fixed deposit till the 18th of the age of majority is just and proper. But we have to set aside the portion of the judgment of the learned single judge directing that if he survived, he is permitted to withdraw the amount. Otherwise, the deposit amount shall be reverted back to the respondent, as the same is not legal and valid for the reason that once compensation amount is awarded by the court, it should be go to the claimant appellant. Therefore, the victim claimant are legally entitled for compensation to be awarded in their favor as per the principle guiding factor laid down by this court in a catena of cases, particularly in Kunal Shah's cases referred to Supra. Therefore, the compensation awarded by the motor vehicle tribunal, consumer forum, state consumer dispute redressal commission, national consumer dispute redressal commission, or high court would absolutely belong to such victim claimant. If the claimant died, then the succession act of this respective religion would be applied to succeed such estate by the legal heir of the victim, claimant, or legal representative as per the testamentary document if they choose to execute the will, indicating their desire as to whom such estate shall be go for their death. For the aforesaid reason, we hold that question of the direction of the learned single judge contained in the subpara 5 to the effect of rupees 30 lakh compensation to be awarded in favor of the appellant if he is not alive at the time of he attained the majority, The same shall be reverted back to the respondent Nigam after paying ₹5 lakh to the parents of the appellant is wholly unsustainable and is liable to be set aside. Accordingly, we set aside the same and modify the same, indicating the operative position of the order.
That is what I am reading.
But this whole judgment speak about the man, and this regulation also discuss man, Electricity Act also discuss man.
Mr. Pathak, you take instruction. If it can be revised.
Lordship, there is just one difficulty with, I am appearing for the FEDCL in this matter. These are regulations framed by the AERC, Your Lordship. It's a statutory body, Your Lordship, under the Act. So perhaps notice will have to be issued to the AERC to come and respond, Your Lordship. It can be revised.
You can inform them that we want their assistance
Very well.
next week.
Most obliged.
Item number 7.
So this is appeal by the revenue against the order of the
Serial number?
item number 7. Lord.
It's a fresh matter. We need to notice.
Talks.
Next.
Lordship.
Item number 8.
This is also fresh. Different. We need to notice. Notice. Next.
Your Lordship, the notice was sent to the appellant at a wrong address deliberately. Very well.
We are issuing notice. Next.
Item number 9.
Here also we'll issue notice. It's a fresh matter. We'll issue notice, sir.
My lord,
We'll issue notice.
actually violation of the aluminum, maybe so we are filing the appeal against the aluminum also. 20 lakhs was awarded, but we have no income to pay. In order to be paid in case, so that also may be stayed, my lord.
Next.
Item number 10.
Yes,
I have taken the instruction from the client, my lord. They are, deceased husband did not file civil case, my lord.
Huh?
Did not file any civil case after the withdrawal of the, my lord, after the disposal of the appeal before this honorable court, my lord, regarding his dismissal from service, my lord.
then forget it. Here are 7 of the judgment. Because regulation 22 will come in your way. Sorry. Dismiss.
Item number 13.
13 to 17. 13 to 17.
13 to 17.
These are appeals filed by the Assam Power Distribution Company Limited. We have also filed interlocutory applications in these appeals, Your Lordship. May I pay the notice be issued in those IAs, Your Lordship?
Dr. Saraf appear. You appear.
In fact, on the time when they are also issued notice in the appeal, we were declining to pass an stay order. And we also directed the minor and petition that whether we want to withdraw this appeal or not. Now he is filing the petition for stay of the
We are conscious about our order dated 27/9/2022.
Well, in fact, with due respect to Lordship, the issue is fully covered by the Supreme Court judgment, my lord. That, my lord, after the all proceedings were over, they have changed the terms and conditions of payment. And the single judge said, my lord, that cannot be done, and they have forfeited the security on that ground.
So not only that, Mr. Pathak.
Lordship.
So I was trying to search. In fact, I called upon my brother also to help me out. See, there is one contract which is over.
Lordship.
Now, your action of recovery is from another contract,
No, from the same.
from the same contract. Now, if everything is over, if you want to file, you can take civil recourse available.
Lordship.
File civil suit.
In fact, what we have,
Recovery.
what we had done, your lordship, was that since they failed to, after being awarded the contract, they failed to execute the work.
Did you give no due certificate or not?
No, your-
Now, contract is over.
no, contract was never executed by them.
It was
terminated,
terminated.
lordship.
Therefore, now, whatever you want to say, it would be a civil dispute,
That is precisely our case, your lordship, that it should be a civil dispute,
not by way of
not by way of.
recovery.
Yes, your lordship.
If you want, you should have gone to civil court.
But your lordship, we had encashed the bank
Anyway,
guarantees, your
you
lordship.
take instructions. Dr. Saraf is correct.
But just one aspect of the matter, they had come in with petition, your lordship.
We are conscious about the
Lordship.
fact.
Yes.
Therefore, you are here as a appeal.
Yes, your lordship.
Just take the table of 11, 12, just take the table, 11, 12. Para 11, 12.
Paragraph.
11 and 12.
Either you take instructions or we fix up the matter and you argue the matter. What else can be done?
Lordship will take instructions, your lordship.
Take instructions. 3 weeks. Next.
The number 19,
Here.
Then appeal by the state, my lord. You can see orders per run a single judge to pay the salary to 29 persons who claim to have been appointed in schools and later on regularized. My lord, the appointment of the petitioners in schools were after the provincialization of the schools, and it has been found on inquiry that the very regularization orders were not issued by the persons.
No, but
In
have you annulled those orders of regularization?
My lord,
Have you annulled those orders of regularization?
yes, my lord, that was annexed by them in the
What
repetition.
we are asking and what you are answering, Majmudar. Has anybody withdrawn or cancelled those orders?
My lord, no, because they were never issued by us.
But now they are on record. Have you taken any action against them?
But they are not available in the government records at all, my lord.
No,
They were totally fake
Did
and
you
false
point out,
papers.
did you point out that to the London single judge?
My lord, of course, in the parawise comments and we were given the records, but somehow it did not come up in the affidavit in opposition. my lord.
File a
Therefore, we preferred a review, my lord,
That
leaving
review
on
is
record
also,
all those documents. But the learned single judge again held that since they were not part in the repetition and they were not documents which are not in the knowledge of the government, therefore the case of review was not made out. Rather, it may be a case
it
of
is
appeal,
question of three years salary.
my lord.
What,
My lord, 3 years salary and their continued service thereafter, my lord. Also the current salaries.
no, but for at present they are in service.
My lord, no, we don't recognize them as to be in service, my lord.
Who
They say they attend the
who
schools.
pays the salary to them, right?
We-
away?
No, they are not getting their salaries. No salaries are being paid to them.
We'll need to know.
The moment it was found out that they were not entitled to salaries, we had stopped the salaries, and at that point of time, they had approached the honorable court, my lord.
We'll issue
Thereafter,
notice.
salaries were not paid. My lord.
We'll issue notice.
My lord.
Next.
May I make a little submission, my lord?
We are only issuing notice, Mr. Chaudhary.
My lord, I am making a prayer for release of, my lord, since 1999, they are without salary. And
Right.
again, my lord, in the event your lordship allows this petition, my lord, by whatever judgment of the Honorable Supreme Court, my lord, we will be entitled to at least 50% of the area and current
Let
salary.
us-
On that basis, my lord, we say something, my lord, at least let them survive, my lord. May I place the decision of the Honorable Supreme Court?
Next.
Oblige me.
My lord, the question is, they have lost the criminal case. In the criminal case, they have found that these are not fraud documents. The criminal case, the final report has been given. This place, in fact, my lord, the affidavit which have been filed.
Therefore, Mr. Chaudhary, we only say that it requires some consideration by the division.
My lord, I understand, my lord. Another aspect, my lord, I must inform your lordship. One of the respondents, petitioner has died, my lord. Respondent number 21. And my lord, the affidavit, the pleadings which are there in the review application, those are not on record. My lord, that has not been annexed to the writ appeal.
Mr. Majmudar,
My lord, I'll file a compilation.
next.
The entire record.
Number 22.
Item number? Service is not. Await service. Service is not.
Mayor, please, your lordship. Lordship, as per office note dated 15/11/22, lordship, neither unserved notice nor AD card has returned back. Lordship, in this regard, I pray for deemed to be served, lordship.
No. Out of question. Next.
Obliged, lord.
Item number 23.
Lord, I have seen, Lord, they have filed a criminal petition before the High Court against the discharge of the passed by the session judge. And the Honorable High Court, Janagar Bench, Miller, has issued notice in the criminal petition.
When is it coming up?
Sorry, my lord.
When is it coming up before the court?
Next date, 4 weeks, my lord, after 4 weeks.
3 weeks, my lord.
Sorry, my lord, 3
3
weeks.
weeks, my lord.
So we. keep
Order
this in
dated
the-
14/11/2020.
Lordship.
We wait till some orders may be passed in that 19th of December. Let us
My lord.
next, because it will have direct bearing on this.
Yes, my lord. Deeply obliged.
Item number 24 and 25.
Look and
Wait, please, your lordship. So this matter can be decided by examining the records instantly. And when it is pointed out, Lordship, this honorable court on 21st of March directed the dominant advocate, planning dominant advocate to produce the records, Lordship, you can see. And if records come, it can be decided, only matter of record, Lordship. Planning dominant advocate then had undertaken to submit the record within 4 weeks. The records have come, Lordship, it can be decided or they will be directed to produce the records, Lordship.
March. Yes, Mr. Majmudar.
I have sought for the records from the school. Before the learned single judge, my lord, the copies of the records were produced. Now I have sought for the original records from the school. Somehow they have not reached, my lord. Maybe next week I'll have them, my lord. Today I had a discussion again.
2 weeks. To comply with the order dated 21st of March, 2020. 2020. 2021, 21/3. 2022. At the request of Mr. Majmudar, mentioned that. Next.
Oblige me.
Item number 26.
Oblige.
He was to file it.
Please, lordship. Lordship, we are in the process of filing affidavit in opposition today itself. Respondent number 3, lordship.
Next week.
Oblige, lord.
Next.
Item number 27.
In this case, your lordship, I have taken instruction from the bank, your lordship. As on date, your lordship, she was to pay your lordship 3,65,500. And bank says your lordship in 3 installments, your lordship, she can pay.
For instrument, maybe hidden.
He said your lordship 4 installments.
Finish it up.
Lordship.
Both of you try to flesh out your difference.
I will have to take instruction from bank, otherwise there's 3 installments.
At least you pay the first installment. If you want, when will you pay?
After 15 days.
Huh?
After 15 days.
Mr. Borthakur. Mr. S. Borthakur, learned counsel appearing for. The bank states that the total amount due and payable by the petitioner
3,65,500.
being
65,500.
3,65,500.
Yes.
Be paid by the petitioner in 3 equal installments. As against this, Mr. Islam, learned counsel appearing for the petitioner, suggests that 4 installments may be granted in order to test the bona fide of the petitioner. The petitioner shall deposit an amount of rupees 1 lakh with the bank on or before 30th of November, HN to 6th of December. Next.
Obliged.
Number 28.
Mr. Islam, you have to deposit 1 lakh of rupees. You please explain to him, Mr. Borthakur.
Lordship.
You please, whether he has understood the order or not, please tell him.
He has understood. Here, your lordship, readings are completed. Readings complete, but your lordship, some order has been passed by the learned CJM, your lordship, granting compensation to one of the those persons killed, your lordship. I want to brought that to the record, your lordship, by filing an additional affidavit.
3 weeks. Next.
Obliged. Lord, I
Number 30.
But in item 30, I'll get the, I'm getting the affidavit today, but I'll give it 2 days time, I'll file immediately.
But then you will get some time to.
It's ready, my lord. The instruction I received, I submitted on last occasion. Just the affidavit I have sent, my lord, it's coming, my lord, on the way. By today, I'll get.
But do you keep it on Monday or you want more time?
My lord, if I receive it today, by Monday, I can file.
Let it come on Monday.
Yes.
Next.
Number 31.
Yeah, I think we replied.
My lord, affidavit was required, affidavit from the respondent number 6. No? They have not filed, and the respondent, it is the, my lord, Ministry of Environment and Forest.
Lordship, we have filed our affidavit today, Lordship. Yes, Lordship, Mahatma. Respondent number 3 to 7, Lordship, and 11.
Next, give some date. The joint request. Next.
Obligation.
Number 32.
May I please your lordship?
Yes, Majmudar.
My lord, I have filed affidavit on today lordship. I mean, it has come on record.
Majmudar, you have received it?
I have received lordship. Today morning itself.
Extend the pleadings Here. Next.
Obliged.
Item number 33.
2 weeks.
In item number 33, your lordship, so far as the IAs are concerned, your lordship, for implement, we have filed our objection, your lordship. And in the main case, your lordship, respondent number 4 has filed the affidavit. We have filed our reply today, your lordship. Today, just now, we have filed, your lordship, and central government has not filed their affidavit, your lordship.
Next.
Obliged.
Next.
Item number 35.
It's 34 is mine. This is this. Appeal is dismissed.
May I please to lordship?
Appeal is dismissed. Next.
Item number 39.
Same thing. Appeal is dismissed.
Item number 40.
I think 4 to 6 are not out. Respond number 4 to 6 are not out.
In this case, I am appearing on behalf of respondent of 4.
4.
I filed a memorandum of appearance.
You have filed.
Yes, yes. My name is Stone also.
No, office report says that. 4 to 6 unsolved. To await notice. 5 and 6 are yet to be solved.
Lord, I am for respondent of 4 only.
Give some date. Next.
Item number 41.
That is the lordship. Well, there is a delay of 51 days in preparing matrimonial appeal balance. Notice it will serve by
We have received a copy, ma'am.
Delay condone. Next.
Obliged.
Obliged.
Item number 42.
हाँ कोई भी डेट दे देना.
Well, there is delay of 11 days, my lord.
Who is there on respondent? I think I have noticed one private respondent is there.
Yes,
Number 4.
4.
Trustee service to number 4.
That's the one. Yes.
Next.
Deeply obliged.
Item number 43.
You are for the respondent?
Section number 1 and 2.
Both the respondents.
My learned friend is appearing for 3 and 4.
3 and 4.
3 and 4. We are appearing for the applicant, so we will condone the delay. 211 days. Next.
Number 44.
We have filed this I to condone the delay of 122 days, lordship, in filing this net appeal.
Who would be appearing for the respondent?
Lordship, this is the first. We will have to.
Notice to be served by registered post 80. It's difficult for you to serve him because he is in armed forces. He might have been transferred. We don't know.
Yes.
His old address is of Madhya Pradesh.
Lordship, we have been informed that he is currently posted there.
There.
Yes.
After, keep it in January. Next, it will take its own time. Next.
Item number 45.
There is a delay of 20 days, man.
Delay condo. Next,
Similar appeal has been admitted before.
it will have to be numbered.
Yes.
Next,
Item number 47.
Yaman.
May it please your lordship,
Lordship, I'm praying for adjournment of the matter today. Lordship, my senior is not well. Lordship, kindly take up the matter after 3 weeks, Lordship.
No. I thought Manoj, you is very particular. Next,
Much appreciated, sir.
Item number 48,
here.
Yeah, please, your lordship. This is an appeal, lordship, under section 19 of Hindu Marriage Act, lordship. Against judgment and order dated 3/12/2018, lordship. And decree dated 15/12/2018, passed by the learned principal just family court number 2, Kamrup Metro at Guwahati, lordship. The appellant has, as a petitioner, filed the application seeking divorce from the respondent, lordship. And after receiving the summons, the respondent appeared and filed written statement, lordship. Thereafter, the appellant adduced evidence. He was cross-examined, and the respondent thereafter adduced evidence. She was also cross-examined. Thereafter, after hearing both the parties, lordship, the learned principal judge dismissed the application, lordship.
So what was the ground of
Ground is, lordship, the respondent was treated by cruelty by the appellant was treated by cruelty. Sorry.
You are telling the truth.
No, lordship.
You are telling the truth.
I beg apology, lordship.
Read para 8 of the judgment. Start reading from para 8.
Judgment is at, lordship.
Read para 8 of the judgment. Issue number 1 starts from para 8. Because ground was cruelty.
Yes, lordship.
Whether you have been able to prove cruelty or not, let us see.
Yes, lordship.
It was whose cruelty?
The fact is that, lordship, after marriage,
You read the judgment.
Okay.
Fact will. This is not a writ petition. We have to stick to the pleadings only.
issue number 1 is, lordship, whether the respondent has treated the petitioner with cruelty. And that is at page 33, lordship, of the memo of appeal. The facts being brought by the petitioner in his evidence is that since after the marriage, the respondent quite often used to visit her parental home, and thereafter he came to know that the respondent is suffering from some gynecological problem for the last 7 years, and she was undergoing medical treatment at Nogao, for which she frequently visited her parental home. And when he asked about giving birth to baby, then she asked for adopting a child instead of giving birth to any child. On 27/6/2014, he told the respondent that he would take her to a gynecologist for her better treatment. But the respondent, without giving any importance to the same, went to her parental home on the subsequent day. And then again, he asked the respondent about baby. Then she told that she did not have any intention to marry him, as she had relation with one Mr. Udhaditya and is not happy with him. In the month of October 2014, the petitioner, after discussion with his parents and the respondent's parents, took the respondent to gynecologist, and after various tests, she was advised for a minor surgery. But the respondent denied to go for the same and said that she is not interested in giving birth to any child. The respondent on 14/2/2015 told to the petitioner that she got news from one of her friends that there is a newborn child in a poor family of Osua, Nogao, and the natural parents of that child are also intending to give the baby if they intend to adopt the child, to which the petitioner refused, for which the respondent started to abuse him in filthy language and started to involve into frequent quarrels with him and his parents. The respondent never took care of her bedridden father On 5/3/2015, the respondent finally left her matrimonial home and went to her parental home. Since then, she has been staying there. It is pertinent to mention that the perusal of the evidence being adduced by the petitioner reveals that the vital fact as being brought by the petitioner against the respondent is that she refused to go for the relevant treatment to bear child, or in other words, refused to bear child, hereby appears to have got the fact of being treated with mental cruelty. It appears that the respondent has denied the entire facts as being brought by the petitioner in his evidence. The respondent in her evidence brought the fact that after the marriage, that they consummated their marriage and had been trying to conceive child, but due to unknown reason, they could not succeed in conceiving child. Thereafter, they visited gynecologist, and on being advised by the concerned gynecologist, the respondent underwent ultrasound whole abdomen test on 19/11/2014. And from the said test report, they came to know that the respondent is not suffering from any gynecologist problem as such, but she is actually suffering from EUJ obstruction in left kidney, which is a kidney-related medical problem. The petitioner never took the respondent to any nephrologist, but instead took her to different gynecologists who suggested different treatment, which were not related in any way to the actual kidney-related problem of the respondent. On various occasions, the respondent also requested the petitioner to take her to the All India Institute of Medical Science, New Delhi, for her treatment. But the petitioner and his mother pressurized her to undergo surgery at Guwahati by threatening her that if she does not undergo such surgery, the petitioner would file a divorce case against her. On many occasions, the petitioner called the respondent a witch merely because the respondent refused to undergo surgery at Guwahati without consulting a nephrologist, and requested the petitioner to take her to the All India Institute of Medical Science, AIMS, New Delhi, for her treatment. Thereafter, the petitioner and his family member drove her out of her matrimonial home on 5/3/2015. After treating her with cruelty, and then did not allow her to enter at her matrimonial home in spite of her repeated requests. She further deposed that petitioner, after driving out from her matrimonial home with malified intention, filed a false complaint petition by reference number FCC/APMS/CL 7303/2015 dated 2/8/2015 before the Family Counseling Center of the Assam Pradeshik Mohila Samiti Guwahati against the respondent before filing the instant divorce case, wherein the said Family Counseling Center by counseling report dated 14/9/2015 recorded its finding after hearing the parties that though the respondent wants to live with the petitioner is not at all ready to live with her anymore and don't want to consult any doctor for her treatment, and he needs divorce just because of her complications relating to her pregnancy, which may be solved through medical treatment, and she proved the said counseling report as Exhibit 1. The respondent categorically deposed that he was always ready to give birth to children, but the petitioner neglected her always and did not provide her proper treatment. It appears that the petitioner, in support of his contention, examined his mother, (PW3) and one Hanuba Begum as PW2. The evidence on record reveals that Hanuba Begum, PW2, is working as a domestic help in the neighborhood of the petitioner. The perusal of the aforesaid witness, Hanuba Begum, PW2, nowhere reveals any fact which suggests her having any direct or personal knowledge regarding the relationship between both the parties or their problems of disputes. It appears that the said witness only brought the fact on record that she saw the respondent to come out of her matrimonial home on 15 March 2015. And except the said fact, she had
failed to bring any other fact on record. The perusal of the evidence of the murder of the petitioner, though reveals that she had reiterated the facts as being brought by the petitioner, but the same cannot be relied on solely without any other cogent corroborative evidence on record. It is pertinent to mention that the perusal of the entire evidence on record nowhere reveals any cogent corroborative material being brought by the petitioner to substantiate the fact that the respondent suffered from any gynecological problem or had any knowledge of the same prior to her marriage or after her marriage. She often went to her parental home for any gynecological treatment. As being alleged by him, the perusal of cross-examination of the petitioner clearly reveals that it is an admitted fact that respondent went to many doctors with the petitioner for the relevant gynecological treatment, and further an admitted fact that he, along with the respondent, tried to conceive child for 1 year but could not. The perusal of evidence on record reveals that admittedly both the parties after their marriage stayed together, or in other words, led conjugal life only for 1 year, and during the said period of 1 year, admittedly both the parties made effort to conceive child, which appears to cast doubt on the fact as being brought by the petitioner, stating that the respondent refused to bear child or refused to go for any treatment to bear child. It appears that the petitioner in his cross-examination admitted that the respondent went for HSG as being advised, though he brought the fact that it could not be done due to some medical reasons, which further suggests the effort or intention of the respondent to have child. It is further an admitted fact that the respondent, along with the petitioner, went to Dr. Meghali Devi, who referred the respondent to Dr. Singhania, but the petitioner admittedly did not take the respondent to the said doctor, though he deposed that could not take the respondent to the said doctor as she fled away from his home in the month of March 2015. But the said fact does not appear to be reliable, as he further admitted that he took the respondent to Dr. Nilakshi Phukon Kumar instead of Dr. Singhania. He further admitted that Dr. Nilakshi Phukon did not advise for any medical treatment, but she referred the respondent to Dr. V. Nahata. It appears that though the petitioner deposed that Dr. V. Nahata advised the respondent to go for surgery, but he admitted that he was not told by the aforesaid doctor about the said surgery. All the aforesaid admitted facts clearly reveals that the respondent always cooperated with the petitioner to go for relevant treatment to conceive child, and thereby strengthen the doubt of the credibility of the relevant facts as being brought by the petitioner. It appears that the fact as being brought by the petitioner in his evidence regarding the respondent of having any relation with one Mr. Udhaditya prior to their marriage nowhere appears to corroborate the contents of this original petition. Rather suggests the same to be totally a wild allegation leveled against the respondent. The perusal of the cross-examination of the respondent reveals that the petitioner has nowhere denied or challenged the fact as being brought by the respondent in her evidence, stating that she, on being advised by the concerned gynecologist, underwent ultrasound whole abdomen female test on 19/11/2014. And from the state test report that they came to know that the respondent is not suffering from any gynecological problem as such, but she is actually suffering from PUC obstruction in left kidney, which is a kidney-related medical problem. But the petitioner never took the respondent to any nephrologist, but instead took her to different gynecologists, who suggested different treatments which were not related in any way to the actual kidney-related problem of the respondent. Even after her request to take her to the All India Institute of Medical Science AIMS, New Delhi for her treatment, it appears that the petitioner has also nowhere denied or challenged the counseling report as being proved by the respondent in her evidence as Exhibit 1. Hence, in view of the foregoing discussion, this court is of opinion that the petitioner failed to adduce any cogent, corroborative, and reliable evidence to prove the fact of being treated with the cruelty by the respondent. Accordingly, the instant issue is answered in negative.
So what is the evidence on record? So that we can appreciate. Use the exhibit number.
Lordship. In evidence on affidavit, Lordship.
Exhibit number.
D5, Lordship.
Hmm?
D5.
D5.
There is a department of a laboratory test, Lordship, where it is revealed that her S creatinine is 0.67 mg, which clearly reveals that her
Anyway, we'll look into the original record. So what are your contentions?
my contention is that, Lordship, the petitioner and respondent, appellant and respondent, could not cohabitate, Lordship, due to some small health problem of the wife, Lordship. Therefore, they went to a gynecologist, Lordship, and the gynecologist, after consulting with both of them, asked her to go through a HSG test, Lordship. The HSG test could not be done due to small passes, Lordship. It has been stated by the doctor in D9, Lordship. Gynec format, Lordship. The HSG test is, Lordship, hysterosalpingography is an X-ray procedure that is used to view the inside of the uterus and fallopian tube, Lordship. In HSG test, a thin tube is entered through the private part and cervix, Lordship. Cervix or cervix, I don't know. So that HSG test could not be done only due to small passes, Lordship. And doctor advised her that you just go through a minor operation, then you will be able to cohabit. But instead of cooperation, Lordship, the wife adamantly requested, Lordship, the respondent that she won't go through operation in Guwahati. He has to bring her to Delhi AIMS, Lordship. And the husband is a peon, Lordship. He earns, at that time, he earned at around 4,000 to 6,000, Lordship. It was not possible for him to bring her to Delhi AIMS, Lordship. And cross-examination of the wife, DW, clearly reveals that she don't have any kidney problem, Lordship. The report says in D8, Lordship, exhibit D8, there is a radiological report, Lordship, ultrasound hollow abdomen female. Last impression is stated that USG reveals left renal status as described, likely to represent UG obstruction. Uterus is normal in ecomorphology with triple line endometrium. Ovaries are normal. Lordship, PUG means pelvic ureteric junction. PUG obstruction is not a kidney disease, Lordship, itself, though it may damage kidney, like, Lordship, kidney stone. Kidney stone is not a kidney disease, but the kidney stone may damage the kidney, Lordship. Just like PUG obstruction is not a kidney disease, Lordship. And in her written statement, Lordship, PUG is no, Lordship, it is a small cyst which develops in the kidney of male person, Lordship.
Mr. Counsel,
Male and female.
asking you further than what my brother is asking. Is that this is anything to do with her capacity to conceive?
Lordship, actually, they could not cohabitate.
That is another aspect.
Yes, Lordship.
So where is the element of cruelty?
Element of cruelty is that, Lordship, she did not cooperated with her husband to conceive a child, Lordship. I have already submitted an honorable decision of Supreme Court, Lordship. That is.
We'll go little slowly. This is final hearing. Don't jump to it. You first complete it. So she did not cooperate in conceiving the child. That is the cruelty.
Moreover, she did not allow the respondent appellant to do physical relation with her, Lordship.
Where is that evidence?
It has been admitted in her cross-examination, Lordship. May I go through the cross-examination, Lordship?
Read it.
Cross-examination of Srimati Mrinalini Sarkar on 4/9/2018. I know that the petitioner has instituted the instant case seeking. Lordship, before reading it, I want to submit that regarding kidney disease, Lordship, she did not reveal a single word in her written statement. It was afterthought and she adduced everything in her evidence.
You first give this answer. Where is you told us that in cross-examination she has admitted that she never permitted any physical relationship with the husband. Please concentrate on that.
They were. I know the petitioner has instituted the instant case seeking decree of divorce. The petitioner is my husband. My marriage with the petitioner was solemnized on 8/2/2014. I am presently staying at my parental home. Since 5/3/2015, I am staying at my parental home. I am having homeopathy medicine continuously for my kidney problem. I have not submitted any documents to show that I am regularly having medicine for kidney disease. While staying at my matrimonial home, my husband, that is the petitioner, took me to 3 doctors. All of them were gynecologists. Since prior to my marriage, I was having pain on the left side of my back and do not remember the exact period when I developed kidney problem. Since prior to my marriage, I am having homeopathy medicine for my kidney problem. Whenever the pain increased after my marriage, when I was taken to first gynecologist and I underwent sonography test, then I came to know that I am having kidney problem. I do not remember the exact date, but maybe it was 19/11/2014. When I did sonography test, my husband, petitioner, never took me for treatment of my kidney problem. I am still having homeopathy medicine for my kidney problem. I am undergoing homeopathy medicine instead of allopathy, as I know that homeopathy treatment is better for kidney problem. See, by her choice. While staying at my parental home, I have never gone to any nephrologist to the treatment of my kidney problem. My husband, petitioner, never took me for treatment at All India Institute of Medical Science, Delhi. Presently, I have not gone to any gynecologist. Prior to my marriage, I never gone to any gynecologist. It is not a fact that due to any gynecological problem, I did not create any physical relation with the petitioner. There was no physical relation between me and the petitioner since after our marriage, as I was diagnosed by the concerned gynecologist to undergo surgery, and I wanted to do the said surgery at All India Institute of Medical Science, Delhi, but the petitioner refused to take me to All India Institute of Medical Science, Delhi for the such surgery. I suggested the petitioner to adopt the child. This statement reveals that Lordship, she was not interested to physical relation, and that's why.
Don't be a storyteller. Restrict to your evidence. You are not permitted to be a storyteller in office. Don't treat evidence in such a twisted manner. It's unfair, not only to the party, but to the court also.
And other reasons are also there, Lordship. May I go through my affidavit in opposition of the husband?
That we will consider. Any other evidence led by you?
Lordship, may I go through the evidence on affidavit?
That we will go through. We are bound to go through.
Yes, Lord.
That you don't worry. Any other evidence is there on record?
Yes, Lordship.
Which evidence you have led? Or and above your examination in chief and your cross-examination. That will,
Lordship,
any independent witness has been examined? Any doctor or somebody?
Lordship, whatever about the medical documents, Lordship, the wife, the respondent has not denied, Lordship, those statements.
Can you not answer to what we are saying? Is there any evidence, independent evidence of any doctor or anybody?
No doctor was called for
Tell us
evidence.
that you have not examined.
Lordship, the wife, the respondent never denied that regarding the document, never challenged the documents, Lordship. That's why we did not call any doctor. They did not challenge that those documents are false, not true.
Yes. Anything else? Anything else?
Yes, Lordship.
Please tell us.
Moreover, the unilateral decision of the wife after marriage not to have child, Lordship, is also amounts to cruelty, Lordship.
Yes.
It has been clearly admitted by the wife in her cross-examination, Lordship, that she advised to adopt a child. And that decision of the wife was unilateral, Lordship, not bilateral. So that amounts cruelty, Lordship. And that has been admitted by the respondent, Lordship.
Yes.
Moreover, Lordship, the respondent in her cross-examination admitted that after marriage, they are not in physical relation.
Yes.
Lordship, and the allegation regarding the ill treatment towards the respondent and his mother, Lordship, that has been stated in the evidence on affidavit as well as in the plaint of the divorce application, Lordship, that has not been, the evidence has not been denied by the.
No, please repeat it. We could not get allegations regarding ill treatment
Towards the respondent and his mother, Lordship.
his mother or her mother.
Sorry, Lordship, appellant and his mother, Lordship.
Be clear,
I
sir.
apologize, Lordship.
Is not denied.
Not denied, Lord. Facts admitted, Lordship, need not be put proof, Lordship.
Yes. Yes.
Lordship, is not a ground lordship, but the fact is that it was concealed by the respondent that she was having homeopathy medicine for her so-called kidney problem, lordship, and that has been admitted by the
So
respondent.
that
in her
amounts to cruelty.
lordship.
That amounts to cruelty according to.
Not cruelty, that is fact, lordship.
No. You can say that that also amounts to cruelty. Why do we leave it?
As per ground, that's all, lordship.
Anything else?
Lordship, my humble submission is that the judgment and decree passed by the learned principal judge, Family Court Guwahati, which have been passed on 3/12/18, lordship, in 6/1 FC civil case number 6/18/2015. Maybe set aside, lordship, and the reversed application of the appellant may be allowed, maybe decreed, lordship.
Do you want to add anything, sir?
May I please, Lord. If we consider the evidence on affidavit of their part.
Huh?
But if we consider the evidence on affidavit of their part. And lordship, all the document, medical document annexed by them.
Hmm.
All are the lordship proof of that we are cooperating with him. Whenever he took me to hospital, we are ready to, and each and every day we appear to present before the doctor, and all the examinations were done. And the lordship undertaking the cross-examination part, which my learned friend is quoted. Last portion. It is not the fact that due to my canon problem. Okay, this is the suggestion. This part is the suggestion part. And he is relying on this part. Otherwise, there is no cruelty because marriage was convened on February 2014. And thereafter, various examination was done. Everything, maybe there may be some critical difficulty. But
Or the
May I submit, lordship? I have submitted an decision of Honorable Apex Court, lordship, from our course practice Jaya course that has been with the Texaco, lordship.
it is not in our file. You can give the citation to us.
Lordship. Regarding cruelty, lordship.
You can, copy is not here. You can give us the citation. We'll look into it.
Lordship, 2007,
2007.
4 SCC,
Hmm.
511, lordship,
511.
511.
Any paragraph number?
Paragraph number, specifically, lordship, in paragraph number 101, subpara 12 and 13, Roman 12 and Roman 13, lordship.
We'll consider. Yeah. LCR इसमें रखते हैं ना? LCR इसमें रखते हैं ना, और ये 2007 की कॉपी. Take out a copy from the library and put it in the file. Thank you.
Highly obliged, lordship.
Next,
Item number 49.
Please, your lordship, lordship, this appeal is directed against the order of the learned single judge dated 28/2/19, which your lordship will find at page 85.
so last time it was adjourned at the instance of Miss Devi to take some instructions.
Yes, lordship, it was regarding whether we would be considering,
Uh,
lordship, I have talked with them. Lordship, they say whatever the court.
Consider it, their heartburning is that it was done within the one day international. They wanted
It
to,
is- No,
they say we are a test match player, so
it's not a case of one day, lordship, because this resignation is considered as a two-stage, because,
it was done within one day.
no,
Those
lordship,
both these stages.
No.
It is there in the judgment, Mr.
lordship,
Chaudhary.
it was not the stand in our affidavit before the learned single judge.
No,
The
anyway,
learned single judge, of course, has relied upon the first stage. After that, it goes to the confirming authority, and the confirming authority found. I've gone to that, lordship.
what is the age, Mr. Chaitri?
Now he's about 38.
38. 38 is not that age at all.
But, lordship, fact remains he is out of training for the so many years.
It is decided in his favor.
Lordship,
Correct. This is single judge has decided in,
single judge has decided in his favor, but the fact that there is a two-stage consideration that was not decided. And the learned single judge went on the basis of a circular of the CRPF.
so whatever it is, therefore we ask Ms.
Yes,
Devi to take specific instructions.
lordship.
Consider his case. If you can. Otherwise,
Lordship, I have in fact talked with the authority. Yes, if there is some direction for the court,
why do you want our shoulders to do it? You are a mighty shoulder.
because they have already passed the final order, lordship. Yeah.
No, you can talk to some higher up.
Lordship, let me make a try one second.
Make an endeavor to, we grant you 2 weeks.
Sure.
Next. After 2 weeks.
Come.
कोई है कोई है तो बुला लो, वरना 2 बजे बुला लो.
Hearing list, item number 18.
Call them at 2 o'clock. Oh, yes. Meta pill दे दो ना अभी. You want to discuss something with it.
Item number 1 and 2.
Lordship has already heard, then it was waiting for judgment, then the lordship has to file the written argument that also been filed. Otherwise, the matter can be disposed of on the basis of assurance given by the government that both will be accommodated.
No, but that is why we have not started dictating the judgment.
On the basis of the referral, let that letter be the form the part of the record.
Government access to board का कैसे accommodate करेगा? Government को acting दिया है. नहीं.
I don't think Mr. Bora is ready to tell us that. If he is ready to tell us that, our job would be very easy. Now go to those instructions. Now it says one may be, based on date, one candidate may be approved against that vacancy. If you under. He is saying one is already working.
She'll not be disturbed.
Naturally. Are you ready for that?
May I please to point out one thing, Lordship? Lordship, as per the last communication placed by the government advocate, Lordship, that file has been moved to the personal department. Now, what is the present position and actual position is that the government has asked the Assam Public Service Commission to spare one post from the ongoing recruitment drive.
No.
So we are in the view that no post can be spared from the ongoing drive because the post which was vying by the parties
what
April
they say-
2013, Lordship.
You are absolutely correct. What they say is by virtue of interim order, one post is already vacant from that very is the question of accommodating them in the new recruitment. It
Yeah.
can be done.
That is, the government is requesting the APSC to spare one post from this ongoing drive.
No, that can be done. Mr. Bora, that can be done because in a given case, even the rules might have changed. We don't know. One post is even otherwise vacant. One person is already in service. His or her selection is under challenge.
Yes.
Without disturbing this, it is one post which is vacant is to be filled in, not from the new recruitment. No, he says that it is APMC, APSC.
After comment with my lord. Only for selection.
No. We may not be misunderstood. We want to be very clear.
That's the I am pointing out.
Otherwise, our direction may be misused or misconstrued by the government. That we don't want. For example, we may do so. You take it that way. Then it can go to the new recruitment.
You have to make it clear. Because if it is subjected to a new proceeding, the author is right. If it is not subjected to the new proceeding, but that you should not ask if it take out or take it.
We'll be taking up another matter where advocate general is.
Yes.
You tell us. Yes. So that confusion may not be there. Because we were trying to find out some way out. Our order may be vulnerable on that very ground. We can't do that. We can't tinker with the new recruitment. Our jurisdiction is only limited to the stay which was granted in 2015. And the post is lying vacant. So in order to find out a way out, we are carve out a way out. We are suggesting this. Please make it good.
Okay.
Pass over.
Item number 3 and 4. This is a review application filed by the state of Assam in the geology and mining department, Lordship, on a very narrow campus. There was a PIL regarding, Lordship, large scale illegal activities of mining in a river in Sipsagar, Lordship. And their contention was that there is not sufficient police battalion or force to check those illegal activities. And this honorable court, during the course of hearing, considered various reports and finally passed an order in which there is a twofold directions. That we have to constitute a high level committee. That committee has already been constituted, and also to have a task force under the geology and mining department, Lordship. The state of Assam, Lordship, to that particular department has already started the process for constituting a battalion under the director of mines and minerals department, Lordship. And at the end, it has come to the conclusion that the minerals which are the subject matter of the PIL are sand, gravel, and stones, Lordship. And when we finally see that there is a concession rules of 2013, and under the concession rule, these three ingredients, Lordship, falls under Y schedule. And Y schedule under that particular concession rules of mining and minerals of 2013, Y schedules, the forest department is the authority, the head of the forest department of, and the PCCF are the authorities and under whom there is already a battalion constituted, Lordship, who are looking after the mining activities relating to these minerals, Lordship. So as there is a direction of this honorable court, that direction, Lordship, would kindly see at page 21.
There are 11.
I'd like to place from paragraph 9 on.
Please read.
Considering the contents of Annexure 10, 11, and 12, we find no reason to pass another sets of order in relation to the issue raised by the petitioner. Substantial relief has already been granted. The respondent state agencies are in session of the matter. It has been directed that a task force be created for necessary action. This is one part. There is a specific direction. Considering the totality of the facts and circumstances of the case, we dispose of the matter, however, with liberty to the petitioners to file applications along with supporting documents which are evidentiary value before the high power committee constituted as per Annexure 11. The petitioner would also have the right to bring to the notice of the Mines and Minerals Task Force battalion to be created or has been created by respondents. The incidents of illegal mining. We specifically provide that such representation is required to be made in relation to the fact situation along with the relevant evidence and photographs if possible. This court trusts that the appropriate action would be taken thereon. The court expects the high level committee and the Mines and Minerals Task Force battalion would be created, set up within a period of 3 months. Let the copy be communicated. So this is the basically the observation as well as the direction, Lordship. So in terms of that, Lordship, we have already constituted the committee. And finally, at the process, I'd like to place one paragraph of my review application, paragraph 3, page 5. May I read it, Lordship? The review petitioners respectfully state that pursuant to the Honorable High Court's order dated 21/10/2019, various steps has been taken for implementation of the order of the Honorable Court by creating Mines and Minerals Task Force Battalion. A meeting was held on 2/1/2021 under the chairmanship of the Chief Secretary Assam with the concerned officers of the department, and it was decided that as an immediate measure, Director General of Home Guard and Commandant General of Home Guards Assam will provide 200 AISF personnel to Dikho River Bank in Sipsagar and Saraidao district to prevent illegal mining and encroachment. Moreover, the Director General of Civil Defense and Commandant General of Home Guard was entrusted for submission of proposal for raising an AISF battalion for environment protection, prevention of illegal mining, safeguarding of minerals, mining area, illegal transportation of minerals, etc. Pursuant to the said decision, the senior staff officer, Home Guards G of the Office of the Director General of Civil Defense, by his letter dated 25/2/2021, informed about the procedure for placing 200 AISF personnel and also submitted details for raising a battalion. Subsequently, the Mines and Minerals Department submitted formal proposal to the Finance Department for necessary budget provisions, etc. However, in the meantime, it has come to the notice of the present petitioner, Mines and Mineral Department, that minerals found in the river bank in the Dikho River or other river banks beds are mainly gravel, ordinary sand, stones, boulders, etc., which are wide schedule minerals as per Assam Minor Minerals Concession Rules 2013. As per provision of section 21E and 21I of the Assam Mines and Mineral Concession Rules 2013, the principal conservator of Forest Assam is the competent authority for administration of all wide schedule minerals. The petitioner states that the authority and responsibility is vested with the principal chief conservator of forest and head of forest force to ensure the mining activities of wide schedule minerals are carried out as per AMC Rules 2013 and also to check all kinds of illegal mining activities. The PCCF and the HOF has a full-fledged Assam Forest Task Force Battalion, and this battalion can be utilized for checking illegal minings of wide schedule minerals in Dikho River also. So this is the position, Lordship. So when we realize that there is already a force in existence
No,
under
but,
the Forest Department,
Learned Advocate General,
Lordship,
according to this minor mineral rule,
Lordship,
concession rules of
concessional
2013,
2013,
what is the duties of Assam Forest Task Force Battalion?
under that rules itself,
Hmm.
why schedule minerals, the Forest Department is entrusted to look into those,
No, we understand.
Lordship.
The question is, this battalion is only in name or in shape?
It is in shape also, Lordship. It is in shape also.
Then you do one thing. Produce a duty list of this Assam Forest Task Battalion, and we
Lordship,
will direct them to take care of it.
Lordship.
Because the main
Yes, Lordship.
central idea of the direction in page 11 is to see
Yes,
that there has to be a specialized force for protection
Exactly.
of this mineral.
Lordship.
Now, whether it is major or minor changes only the authority,
Lordship.
but the fact remains that they are to be protected. Even the gravel and sand are to be protected
Exactly, Lordship.
from any illegal mining.
Exactly, Lordship.
Therefore, you spell out
Lordship.
that they will take care of it, and what is the constitution?
Exactly, Lordship.
That is what we are.
I'll produce it, Lordship.
And my brother is correct. You can even issue a notification. That they will be-
The other day I made my submission. If that is required, Lordship, we can do it in 1 week's time. I have taken the consent to make this submission.
Yeah.
And also the other thing which Lordship wants is to see that if Lordship wants to look at the terms of reference or the scope of work of this force,
because
then I can produce that also,
it is better.
Lordship.
Notify the other force to be also a force as directed and give the specialized trade if necessary for.
In fact, in Dikho, it was not might not have been done. But I have gone through all the papers. There was large scale verification and it was found there is no illegal mining at all.
Advocate General,
Lordship.
one thing is certain, that this court found that there is illegal mining to a great
But during the pendency of this case, lot of documents were furnished and which were observed and noted in the order also that there is no illegal mining activities in that area now.
But that is because you are on vigil and this court was monitoring.
Exactly, Lord.
So now we can monitor it for all time. to come.
Absolutely.
Therefore,
Lordship.
we need this. You
Lordship.
clarify it. Now we find that even other parties are there. How will you bring them? State of Nagaland is there probably. Pollution Control Board is there.
They are state instrumentalities, Lordship. There is, Nagaland is on the border of that, border area of that river.
But if they
But
are,
we do not have jurisdiction over there.
maybe, but they are parties, therefore somebody will, Ms. Kiru maybe have to appear.
Our only concern is I'll produce this document and also that
We understand
notification.
it.
That is one part. The
Honored
other-
Advocate General, to oversimplify your argument or the review application is that you want substitution of that special task force with.
Under the geology department,
Only you want substitution.
Lordship,
Prima facie, we are with you,
Lord.
but all the parties should be, and you should ensure that they will, as my brother is indicating, not general under the forest duties. They have to be notified, just as, for example, we designate a particular court to be a special court.
Lordship.
Same thing we want from the government as far as the task force under forest is concerned.
Lord.
Tell us by Thursday.
Lord.
Other, my brother is also correct that pollution board has got a standing count.
Nagaland has also a council,
so
so
you
we
ask-
can inform them also.
You inform them.
We'll inform them.
Thursday we'll assemble. Okay?
Thursday next, Lordship.
Because we want it to be in.
Yes, Lordship. Technically, we have to be correct.
In letter and spirit.
Lordship.
Yes, Mr. Bora.
Highly obliged, Lordship.
Number 1 and 2.
It heard Mr. T. Sakia, learned advocate in the last time, assisted by T. Nath. Learned counsel appearing for the state council. And so on. Let the standing council for pollution board is phone number so and state of Nagaland.
Lord.
Be intimated by Mr. T. Nath about the review and review application, and copy thereof also be served. Adjourn to 24
Highly obliged.
November. Yes, Mr. Bora.
My lord. My lord, that vacancy,
24/11.
is not vacancy, it is a vacancy in earlier vacancy, my lord, because at the time of equipment, there was a, from out of, my lord, I think, one post already kept vacant from that selection only. This is already there. This is not carried forward to the new selection.
No, but that council is not here. He
That-
says that.
That instruction I have received from the Commissioner Secretary Home. He said that
Please
vacancy
come in.
already there since
Mr.
2015.
Datta says, Datta was there, isn't it? Huh? PP Datta was there. He says that your personal department has written a letter to.
No, that, obviously, this is a process, official process, it is sent for by view of the personnel department.
No, he is very categorical. It is from the new recruitment that you are asking. That can be done.
No, the Commissioner Secretary said, no, it is not a recruitment. That vacancy not included in the press recruitment process. That vacancy.
I am
already
getting the
kept.
instruction, I am producing the paper, Lordship, what the APSC is receiving from the government. The only,
Both of you have to settle the issue. You can't fight with each other.
no. I am point out so that there any misconception.
You
can
may
be
take
passed from this
assistance
court.
of Mr. Nair for a change, but not otherwise. You tell us, we'll wait. There is no, because, or you tell us by next Thursday, anyhow, we are
I don't know.
assembling again on Thursday.
I don't know.
Yes,
If you make it clear, then we'll,
yes, that instruction, written instruction, I will put it before.
that is better. That is better.
Yes.
In 2013 vacancy has been exhausted.
You can ask the personnel department to withdraw that.
Yes, obviously, man. I will tell the Commissioner Secretary. Yes.
In 2013 vacancy already been exhausted before the passing the interim order.
This is something new that.
Right.
You make it clear.
Not yet.
It's into 24/11.
May I please? Your Lordship?
Yes.
Lordship, in this case, we have challenged the rejection of my application for issuance of C form and F form, Lordship. Lordship, what has happened in this case is that, Lordship, I am a dealer and I bring the goods from outside the state of Assam for resale. And for that, Lordship, I have obtained a registration certificate also under the Assam Value Added Tax Act as well as the CST Act, which your Lordship will find at Annexure 1 of this of my writ petition, page 23. That is my certificate of registration under the Assam Value Added Tax rule. Lordship, Assam Value Added Tax Act has already been repealed so far as 6 products are still there, but it has now been repealed. It is the case before coming into effect of GST. So, Lordship, this was my certificate of registration under the Assam VAT Act, and thereafter under the CST Act, Lordship, which is at Annexure 2, page 26. The Central Sales Tax Act registration also I have obtained for resale. Lordship, may kindly see that I am dealing with sanitary fittings, steel bars, lots of items I am dealing, but they are for resale, Lordship. So, Lordship, I am bringing the goods from outside the state of Assam for resale within the state of Assam and outside the state of Assam. Lordship, in my course of business, Lordship, I used some delivery notes which were issued by the department, Lordship, and I brought the goods from outside the state of Assam. When I bring goods from outside the state of Assam from a registered dealer, Lordship, I am also a registered dealer, I have to give C form, Lordship, to them to prove that yes, there is a transfer from a registered dealer to registered dealer within 2 states, so that they get a concessional rate of tax in their state. So, Lordship, this C form, Lordship, I get this C form by provision of Section 8 of the Central Sales Tax Act, which gives me the power to take a C form if I am a registered dealer into the state, and I give the C form to the registered dealer. Lordship, this after my transaction was completed, I brought the goods from the outside the state of Assam. I applied for the C forms, but the same were rejected, Lordship, by the superintendent. Lordship, the rejection is at page Lordship 29. That's the rejection order, Lordship. No, Lordship, they have not given me any reason. There is just a simple, I applied for the C form and they have simply said rejected, request rejected. Page 29 is the order, and the status in the status, Lordship, which is the fourth column from the left, from the right, Lordship. It is written request rejected. They did not inform me the reason, and they had rejected my request for Lordship issuance of C form. Lordship, the rejected cancellation, this is written. The dealer has submitted an application regarding online issuance of 17 numbers of leaves of C form, request rejected. That is the Lordship, that's the only thing which they gave. Thereafter, Lordship, I after this rejection was done of my C form, I had applied before the Commissioner of Taxes, Lordship, at page 31, the Commissioner of Taxes for against the refusal to issue C form, and I had prayed before the Commissioner to ask the authorities to issue me the C form. Lordship, at page 31, I had made an application. I had even stated that the state rules empower the officers to withhold the issuance of declaration. But in my case, those rules are not applicable. There is a rule, Lordship, Central Sales Tax, under the Central Sales Tax Act, Lordship, Central Sales Tax Act is under the central government. Now, Lordship, there is a central state Sales Tax Act. Under the Central Sales Tax Act, there is a rule which has been formulated by the state government, not by the central government, Lordship. So under that rule, Rule 8(4)(f), Lordship, there is a power to withhold the C form. But not that is not applicable in our case. That is what we had applied before the Commissioner. But Lordship, this application of mine was not adhered to by the Commissioner, and Lordship, I was not given the C form. Lordship, it was informed that it was also rejected. Lordship, at page 34, I have annexed the rules which was formulated in for so far as this one section Central Sales Tax Act is concerned. The relevant portion your Lordship will find at page 36. Page 36, Lordship, the last few lines, amendment of Rule 8C. That is the Central Sales Tax Rules, Lordship. Central sales tax acceptable. Yes. If your lordship has the Central Sales Tax Act, lordship, the central sale under the Central Sales Tax Act. Lordship, page 36.
Hmm.
37.
Oh.
Lordship,
Yeah.
yes, your lordship. Lordship, page 37 of my petition, lordship. At this moment, my petition, lordship. Page 37. Lordship, last lines. Amendment in Rule 8F. 8F, lordship. Now this amendment in Rule 8F is not the amendment in Central Sales Tax Rules 1957. It is not amendment in that rules. It is an amendment in Central Sales Tax, lordship, Assam rules. There is another rules, lordship, called Assam rules. If your lordship have this book, taxation laws in Assam, there is another set of rules which is Assam rules, lordship. So they have made amendment in Assam rules, lordship. Herein there are some certain restrictions which are placed, which says that, lordship, I'll be reading some few lines in the principal rule. In Rule 8F, after existing.
Now,
Lordship, this in
before
this
you,
book, page
before you take us to this aspect,
yes, lordship,
assessment was made during the pendency of this petition.
during the dependency of this assessment has been made
Have you challenged the assessment order?
before the Deputy Commissioner of Taxes Appeals.
Appeals are pending?
Yes, your lordship.
Lordship, I got the information that appeals have been dismissed, Lordship. He didn't appear and participate. Each time, Lordship, he sought for a turn.
So I don't have any information in this.
Because what we were thinking was,
Hmm.
see, if the assessment is made, then this argument whether it would be available to you right away or not. Because once the assessment is made, the regime is different. You will agree with us.
Yes, sir.
You can have the very challenge
Yes.
that you are entitled to see an F form, though not granted. Because then, even in the, if you see the affidavits which have been exchanged between the parties,
Yes, sir.
the major allegation against the SST or the petitioner is that these are all, delivery challenge delivery, not the delivery of goods.
Yes, sir.
I am trying to oversimplify the stand of the government.
Yes.
Now that can be examined by this court, provided no assessment is there.
Yes, sir.
Once the assessment is made, you will file the appeal. Mr. Counsel says that the appeals are dismissed. Then you have to take care. Maybe now the tribunal would be there.
Yes, sir. Yes, your
Code of
lordship.
Revenue, or in common parlance, it is known as tribunal. Therefore, now you will have to agitate your case there.
Lordship, I
Because in the appeal you must have raised the similar issue that I was entitled to benefit of Form C, which is not granted. Look here, this is intrastate trade. These are the delivery challenge.
Lordship, I agree with your lordship. Lordship, other things I will argue before the appellate authority only regards C form. But if your lordship permits the appellate authority or the revisional authority before whom I are there, that they may also consider my application for C form. But
That is
I
what-
will have
that
no
is what
grievances
we are
there.
saying. You
Yes,
can,
Lordship.
you take all contentions which are available to you.
Lordship, only one fetter is there.
Hmm.
I am agreeable to that, lordship, but only one fetter is there. That as per the Assam value.
Because no stay was granted to you.
No stay was granted.
Therefore, virtually it is academic.
Yes, your lordship. Lordship, in this case, lordship, only one fetter is there that under the Assam Value Added Tax Act, if I go before the appellate authority, I can challenge only the my assessment order. There is
Ultimately,
no power under the act to.
Madam, you may be technically correct,
Yes, your lordship.
but on what basis you are challenging the assessment order that you were you were entitled to concessional rate.
Yes, Your Lordship.
That is your challenge even in the appeal,
No, Lordship. In my appeal, Lordship, what has happened?
because nobody can be permitted to write two OCs at a time.
Yes, Your Lordship. Lordship, what has happened, Lordship?
You should have either been vigilant to see that assessment orders are not passed. You could have asked for some interim relief in 2017 petition, because these assessment orders are after the filing of the petition.
Lordship, in fact, the assessment since they have passed an assessment order, this case become more stronger. Lordship, I'll explain.
No,
Lordship. Just-
stronger, we don't want any academic discussion here.
Yes, Your Lordship.
We will invite you for any other conference.
Lordship, what has happened is that I have brought the goods from outside the state of Assam.
That
This
is
C
what,
form I will give to them. It will not be of any benefit to me. I will have to give
so
the
you
C form
argue
to them.
all that is available to you in, because he says your appeals are also dismissed.
Lordship, for that,
Lordship, I have received just now the order. It was dismissed on 24/10/2019.
Oh,
Lordship, I have no information. Maybe the revision order, revision has also been preferred. In the meantime, Lordship, I did not get the information. I will check with that. Lordship, only thing is that if your Lordship is taking a stand, that it can be this issue of C form can also be taken up. But then this matter can be
Counsel,
demanded to the
we as judges can't take any stand. That prerogative is always of the advocate.
no,
We
Lordship.
have to take a view.
Lordship. Of course, Lordship. Lordship, what has happened? This assessment order which has been passed, which it shows that my goods were in existence. That is the only case, Lordship. I was trying to prove that if the goods were not in existence, on what they have levied tax.
It is one side of the coin.
Yes, Your Lordship.
It is one side of the coin.
So therefore, I was eligible for C form because the goods were in existence. This
therefore-
is not that goods were not in existence.
You inquire and tell us and read the order first.
Yes, Your Lordship.
Assessment order.
Yes, Your Lordship.
What is the divisional order?
Yes, Your Lordship.
Appeal.
Yes,
Department of
appellate
First
authority.
Appeal.
Yes, Your Lordship. That I have to Lordship see.
It is not
Otherwise,
a part of the petition.
not as a part of the petition. Lordship, if Your Lordship may give time only for apprising the court whether my appeal has been disposed of or not, that I will have to see, or any other thing.
Because-
They may
because
have
if
filed
you-
the revision.
No doubt, we'll hear you on this if you want. Otherwise, even in assessment order, the allegation is that your goods never went to Bhutan.
Yes, sir.
Therefore, you are saying that your case is stronger because assessment order is passed, may also require some rethinking at your end.
Lordship, if my goods have not gone to Bhutan, that's okay. Because
No, you have argued everything there, what you are arguing here also.
yes, Lordship.
Maybe the expertise may be different,
Yes, sir.
level of expertise.
Because Lordship, in my case, I am now trying to prove that my goods have come from outside the state.
But
of
you
Assam.
see, in a writ petition, you can't argue what you are supposed to argue before the
sir.
tribunal,
Yes, sir.
having lost in appeal.
Lordship, if your Lordship will finally, if I'll just check whether the appeal is pending and whether they have filed a revision after
No,
that.
he says
if-
that appeals are dismissed in 2019. Today we are in 22.
Lordship, then he must have filed a revision petition. I'll have to check that. But if the revision order, if the petition is filed before the revision,
By
my
this
prayer
time,
would be
the
that
revision also must be over.
my application for a C form may be considered by the commissioner, by the revisional authority himself, along with my appeal.
You
That
first
will be my
inquire whether or you have accepted the appeal order, then nothing will survive.
only for that.
If
Lordship,
no
that I
revision
may
is
be
filed,
able-
you are bound by the appellate order. Now you can't argue to the contrary writ petition.
Yes, sir. Yes, sir.
Take proper instruction.
Yes, sir. Okay.
You have challenged the filing. Filing of the.
Lordship, finally,
That is because you wanted division bench to handle your case.
no, Lordship, at that point of time, Lordship, it was important. Thereafter, that time GST did not come, Lordship. It was important at that
No.
point of time.
Instead of going to tribunal, you wanted a division bench of this court to handle. Therefore, virus is challenged. Don't run away from the reality. That is exhausted now after 5 years. Anyway, we are not in a hurry. Take proper instructions and tell us. Yes, Mr. Chaudhary, any matter?
Once you get the copy, you start.
P. Ahmed is there. P. Ahmed is there. Huh? High progress. Anyway. We don't return any matter. No particular date. Whenever we find time like this, we'll take up.